Good afternoon, everybody. As Mike said, my name is Mike Carr. I've been with Evans & Dixon for 11 years. When I started, I originally did a lot more Missouri. Most of my practice was Missouri, and then I shifted into Illinois, and now I spend a disproportionate and unfortunate amount of time in the state of Illinois dealing with cases over there. Before we go too much farther, I just want to point out a few things. There's a couple handouts in the back. It's been mentioned earlier. The materials for this presentation were put together back in January, but the appellate courts in both Missouri and Illinois have kept on rolling. We wanted to present you with the most up-to-date and current information we could. That's why I added 2 Illinois cases. I believe Michelle added 1. So those materials will be in the back. The other cases will be in the main portion of the book. And I'll try to tell you when we're jumping between the handouts and the main portion of the book. With respect to the written materials, Michelle and I both want to thank Max Huber, who prepared the Illinois case law update for me. He is an associate in our St. Louis office. And Jenny Dancy, she did the Missouri case law update. She's over there. And we want to thank her as well. She is in the Springfield office and is an associate there.
And they can answer any questions that you might have also after we're done speaking today. If you want to corner any of us or either of them, they would be happy to field your questions.
All right. Michelle and I are not going to cover every case that is in the case law update. I'm going to hit 5 that I think most jumped out at me. I think, Michelle, you've got 6 or 7 that really jumped out at her.
Lessons learned cases that would be helpful to you.
And so those are the ones we're going to talk about this afternoon. Going into the great state of Illinois, the first one we're going to talk about is NE versus the Workers' Compensation Commission and the city of Chicago. This case involves the always classic arising out of portion of whether or not an accident occurred. Mr. Nee was a plumbing inspector. What he did was he would present to the filtration plant for the city of Chicago, get his day's assignments, and then go out to 5 or 7 different locations throughout the day. He asserted, and the respondent agreed, that he was a traveling employee because he traveled all over the city of Chicago doing these plumbing inspections. On the day that he had his accident, he had just finished an inspection and was walking out to his car. He went over a curb and tripped. At trial, he was asked by his attorney, "So you believe that the curb may have been higher than the sidewalk and that's where you tripped?" He responded, "Yes, I do." However, on cross-examination, he was less clear. He was asked, "You don't really recollect the curb?" And he said, "I don't know, I didn't take a look. All I know is I tripped and fell." The arbitrator found that he had sustained an accident because he was a traveling employee. The commission reversed. The commission reversed, finding he failed to prove he sustained an accident that arose out of his employment because he couldn't explain why he sustained the accident. The curb was a neutral risk. They didn't consider that it was a defect because everybody in the course of their general day encounters curbs. They didn't think him being a traveling employee took him out of the general public and made it an increased risk, nor did they feel that he had established that he tripped because of the defect in the curb. That was confirmed by the circuit court, and it went up to the appellate court. The appellate court, of course, reversed and reinstated the arbitrator's award. The court reasoned that the curb was a neutral risk. There's 3 categories of risk when you have these arising out of cases. Risks personal to the employee, which are not compensable. Neutral risks, which might be compensable given the situations. And risks associated with the employment, which are always compensable. In this, the court noted neutral risk injuries are not compensable unless the petitioner can establish exposure to the risk at a greater degree than the general public. The appellate court didn't find that the curb was a defect. In their mind, they didn't have to. What they focused on was that the petitioner was exposed to curbs more than the general public because he was a traveling employee. Essentially, they invoked the street risk doctrine. Because he was a traveling employee and his place of business was on the streets, the risks of the street therefore become part of the employment. Because traversing a curb is a risk on the street, the curb became a risk and part of his employment, and therefore tripping over it was enough to make it a compensable injury. Why is this an important case? We all see these cases in Illinois. These arising out of cases happen every day. They are very fact-specific. What I think you're seeing out of this case is the appellate court is going to go out of their way to find these cases compensable. I just argued almost a case on the exact same procedural history and facts as this yesterday.
How'd that go?
Yeah, and I definitely got the sense that they're going to rule against what the commission did, finding that an accident hadn't occurred, and reinstate one there. I think you're going to see a lot more of this coming from the appellate court. The commission, since the recent changes have gone into effect, has become a little bit more conservative and a little bit more gun-shy on finding compensable injuries, whereas the appellate court, I think, is swinging the other way and is more willing to overrule the commission and find these cases compensable. The next three cases I'm going to talk about deal with nature and extent and how that's determined, especially in these days where we now have the 5 factors under 8.1 or 8.1b. The first one is Continental Tire. In Continental Tire, you're dealing with a laborer trainer who sustained a left wrist injury after a slip and fall. He had a chip fracture. He went through treatment. There wasn't any surgery, and he ended up getting an AMA rating from the treating doctor. The respondent asked for one for 0% impairment. The hearing was on the sole issue of nature and extent of disability. The arbitrator went through the 5 factors of 8.1b, which are looking at whether or not an impairment rating was produced and is in evidence and was provided by a competent physician licensed in the state of Illinois, age, impact on wages, evidence of continuing problems from the medical records, and they determined that, or the arbitrator determined that he had sustained a 5% impairment of the left hand based on the application of the factors in 8.1b. The commission affirmed and adopted the decision, as did the circuit court, and it went up to the appellate court. What the respondent did before the appellate court and on appeal was argue that the commission's decision was erroneous as a matter of law. What they were arguing was that they had submitted the only impairment rating report. The petitioner's attorney hadn't got one, as they frequently don't do in Illinois since we've been able to get impairment ratings. And they argued, without evidence of an impairment rating countering the one that the respondent received, the arbitrator should have awarded 0% disability. The commission and eventually the appellate court noted, yes, that's one of the factors, but the Act specifically states it doesn't specify the weight to be given to a rating evaluation, but rather no single enumerated factor shall be the sole determinant of disability. Essentially, the appellate court said, we don't have to adopt your rating report simply because it's the only one. It's one of many of the 5 factors we get to look at, and therefore we can award permanent partial disability regardless of what your impairment rating states. The respondent also argued that the commission erred under the manifest weight standard as well, saying that they gave the improper level of weight to the fact that there was a 0% impairment rating. And again, the court looked at this from a manifest weight of the evidence standard and said, we can't determine from these facts that any factor was given an improper amount of weight. therefore the decision holds. Why is this case important? Impairment ratings are the new thing in Illinois, and everybody's been getting them since we were allowed to start producing them and bring them into effect. However, I think the arbitrators and the commission, again, it's only one of 5 total factors they're going to look at. And I think while impairment rating reports are going to eventually start bringing numbers down, and I think you're seeing that in some arbitration and commission decisions, you're never going to get a 0 simply because that's what your impairment rating is.
Do you think it's still worthwhile and time and money spent to get an impairment rating?
Absolutely, because as I just said, I think awards are going to start coming down with these things, especially with the newer arbitrators. The older arbitrators who operated under the old system for years are going to, I think, keep producing awards that were in line with those prior decisions. But as the newer ones come in and you start applying these more, I think you're going to see the impairment ratings gradually bringing awards down.
Hey, Mike, we have a question in on the text line. In the knee case,
Yes.
Had the area not been considered his work site, would photos and measurements of the area been advisable for possible defense?
So if he wasn't a traveling employee, like,
Assuming he wasn't a traveling employee, I think that's where they're trying to go. I don't know that it would have made a difference. I think usually you see petitioners' attorneys produce that kind of evidence as demonstrative of the fact that a defect did exist. It's up to the petitioner to prove all the elements of the case, including whether or not a defect existed. I think in this case, the defense had done enough to question whether or not he tripped because of the curb, saying by him testifying he didn't really know what caused him to trip in the first place. But in the end, the appellate court didn't focus on that. They didn't focus on the fact that maybe there was a defect in the curb or not. They focused more on, well, he's exposed to curbs more than the general public is because he's a traveling employee. The fact that a defect in the curb existed wasn't what was key. He was exposed to them more, and because he thinks he tripped on it, that was enough to make it a compensable case.
but in some cases it could be really important, like the one you kind of had yesterday. Where
Yes.
they spent a lot of time on the defect of the stairs or the steps. And
Yes,
I think in some
absolutely.
cases it could be really important to have that kind of evidence, but in others where the question is a little bit different, it might not be as important.
Again, those arising out of cases are very fact-specific, and we've done that in other cases where the issue was arising out of, and we've gone and taken pictures to show that, no, the stairs really aren't defective. And that's worked in cases, but again, you have to have the facts for that kind of thing. Okay. Next up is Dorsey. This one's interesting. What happened in this case was Mr. Dorsey had torn the biceps tendon at his elbow for his work-related injury. It was a compensable injury, tried only on nature and extent. And as part of the hearing on the issue of nature and extent, he acknowledged that he had had a prior settlement in 1995, so 20 years prior, to his rotator cuff. At trial, he was very specific to state, the only thing I injured in 1995 was my rotator cuff. The only thing I injured in 2010 was my biceps tendon at my elbow. They're completely separate. When the arbitrator tried the case, she construed the Will County decision, and I assume everybody's familiar with that one, to mean that not only was the shoulder not part of the arm, but neither was the elbow. And as a result, she awarded 17% of the body as a whole for this elbow injury.
So the elbow is not part of the arm anymore?
No, not according to this arbitrator.
Right.
On top of that, because the award was made part of the body as a whole, respondent couldn't claim the credit for the prior injury to the arm didn't apply, because you can't take credits for awards to the body as a whole. The respondent wisely appealed this decision to the commission. And the commission looked at the case and determined that the arbitrator had significantly misconstrued the finding of Will County. The elbow is still part of the arm. I'm
Yay.
sure we're all glad to know that. And awarded petitioners 37.5 of the arm for the biceps tendon rupture that had to be surgically corrected. The other benefit was that now the credit applied. So they got a credit for 30% of the arm, essentially making the award 7.5 of the arm. The petitioner appealed that decision, and that went up to the appellate court. What the petitioner attempted to argue, they had two arguments before the appellate court. The first was that the arbitrator had not erred, that he had had an injury to the shoulder. He tried to argue that, oh, no, the biceps tendon runs up to the shoulder. It's all part of the shoulder. The appellate court didn't buy that. They saw that the medical record specifically described everything occurring at the elbow and noted the arbitrator had significantly misconstrued what Will County stood for. What the petitioner's attorney then tried to do before the appellate court was argue, well, now that same shoulder injury that he settled for 30% of the arm in 1995, today that injury would be on the body as a whole. Therefore, the credit shouldn't apply for that prior shoulder case. And the commission, or the appellate court, rejected that argument as well. They said there was no case law indicating that you could go back and modify a settlement 15 to 20 years after it's been entered. They noted that prior settlement was made when the shoulder was still considered part of the arm. Benefits for that 1995 case were paid under Section 8E, i.e. the arm. So therefore, the respondent could get the credit for an award now being paid under that same body part. They rejected the retroactive application of Will County. Why is this case important? Because it tells us, A, the elbow is part of the arm, and B, more importantly, when you have a prior shoulder case and a new arm injury, you still can get the credit for those prior shoulder cases applied to your new arm injury. It's not retroactive. You can't go back and do it that way. So at the very least, while now the shoulder is part of the body and you can't get credits for new awards for shoulder injuries, you can get a credit for your old shoulder injury for a new arm injury. The next one we have is Nash, and this is another 8.1b case, looking at the 5 factors here. Mr. Nash, at the time the case was tried, he was 54. When it was appealed, he had turned 55. But he was a 54-year-old asphalt helper who sustained a slip and fall injury, minor back injury, while he was working. He treated conservatively, got medications and physical therapy. He had the typical complaints you have with these minor back injuries. He couldn't lift as much. He had some pain, that kind of thing. It was tried only on nature and extent, and the arbitrator awarded 6% of the body as a whole. In doing so, he looked at the factors, and he gave the greatest amount of weight to his advanced, what he called his age of 54, 55 years old, and the type of work that he was doing. He increased what you would typically see on a case such as this because of his age and the type of work he did. He also increased it because petitioner testified at trial he hadn't started his winter duties yet, working as an asphalt helper. And the arbitrator felt, well, I can't determine what impact this is going to have on his wages, so I'm going to give that a little bit of weight too and increase what the award should be. The respondent, again, very tactfully and smartly, appealed to the commission, arguing primarily that no, age, especially, and these are their words, the respondent in this case and the commission, I want everybody to know that now, that 55 being an advanced age means that he has to live and work with his disability for a less amount of time than a younger worker would have to, and therefore you should decrease permanent partial disability rather than increase it under the application of this factor. They also looked at the wage, the fact that we didn't know what the winter duties would be like and the impact there. The commission noted, no, he's back at work full duty, he's not getting paid any less. They improperly considered what his future wages might be in that situation. Why is this case important? I think it shows you how they're looking at factors other than the impairment rating. In this case, you can kind of see what they're doing and how they're applying the age factor under 8.1b. I don't know where advanced age starts in the mind of the commission and the arbitrators, that you can start decreasing an award that you might see versus a younger worker who's going to live with it longer and you have to increase it. But I think...
How are you going to artfully argue that
Yeah,
that
yeah.
petitioner is old? I don't know, but...
But I think you're seeing how they're applying the factors that were put into place in this case. The last one I'm going to talk about today is the Oliver decision. This one's interesting. It was appealed mostly on whether or not penalties and attorney's fees were appropriate. As anybody who does Illinois work knows, penalties and attorney's fees are appropriate when your conduct is unreasonable and vexatious and is meant to delay or block the application of benefits under the Illinois Workers' Compensation Act. What happened in this case was the injured worker had sustained his work-related accident but had not reported it until 6 days after it had occurred. The employer was upset about this, and the respondent denied benefits. They argued that they needed additional time to get medical records and determine the compensability. When it was tried on the issue of the petition for penalties and attorney's fees, they dove down into the facts and determined, no, you denied it because he didn't report it on the day it occurred. And that's essentially what the respondent did in this case. They denied benefits because he didn't report it the day the injury occurred, instead of reporting it 6 days later. The commission, to its credit, actually reversed the award of penalties and attorney's fees, but the circuit court reversed the commission and put them back into effect, and the appellate court affirmed the reapplication of penalties and attorney's fees. The court focused on the fact that penalties were warranted because respondent denied the case solely because he didn't report it on the day it occurred. And they found that attorney's fees were warranted because the action of denying the case was not simple inadvertence or neglect, which are defenses for penalties and attorney's fees, but because the respondent had made a deliberate decision to deny benefits because he didn't report it on the day the accident occurred. Why is this case important? We all have those cases where we're mad because he didn't report it the day it occurred, or the injury, he didn't report it for 15 days, 2 weeks, whatever that is. And our first instinct is to deny benefits because we question accident. We have to remember, they have 45 days to report an accident. And in that time, and we have a reasonable time to investigate claims. But don't deny the case simply because he didn't report it the day it happened. You're going to get hit with penalties.
And I've had discussions with clients before where there's an employer policy in place, or there's a rule that everyone is trained, you must report it on the day that it occurs. How an employer handles not following an employer rule about reporting is an employer question. But Mike and I had talked about this, and I'm like, but the statute gives these people, the petitioners, 45 days to provide notice. And while it might raise some questions, the statute allows 45 days, and it's going to be a really tough sell for a notice defense if they've provided notice within 45 days. So it it is tricky, and I understand probably why this particular employer was really upset, but that's why this played out the way that it did.
Okay, the statute says that they are to report it as soon as practical, but no longer than 45 days. But nobody pays attention to the first part. Can you explain that to me, Lucy?
I can only tell you what the case law tells us, and that's,
Benefit of the doubt, I think,
yeah,
plays in a little bit.
they're always going to construe it in favor of the employee. We all know that. And
That's why most of us take Xanax.
I don't want to know about any personal workers' compensation claims you have.
I know you're not the only one in the room that feels that way.
Yes.
I know. Right. Right.
If I had an answer to that, I would.
Hey, then I wouldn't need so much medication.
Exactly. So we've always said that notice is not the strongest defense, and you all know why, and this is just another example of why notice is not the world's strongest defense in a workers' compensation case.
I mean, I'll fight for it. You know,
Yeah.
any chance I get, I'll give them a heck of a run. But you know, and say that it. But you know, have you ever had evidence of them knowing, and then waiting to report it? You know, that would be a really good argument. But I think more often than not, it's not. You don't have something in hand that shows that they knew about it and then waited 3 weeks to turn it in. It's more often they do whatever they do and eventually get around going to the doctor and eventually get around bringing you the slip, and it's a little bit harder to show.
It's a muscle strain, and they
Yeah.
think taking a couple pills of aspirin will make it go away, and
Right.
it gets worse over the weekend, and then they go to the doctor. We've all had cases like that. So, unless there's any other Illinois-specific questions, I'm going to turn this over to Michelle, who's
I'm going to switch gears. So we kind of separated the cases by state. So if we jumped back and forth, it didn't get confusing. Mike talked about Illinois. I'm going to talk mainly about the Missouri cases. If you have any questions about anything during the remaining time, please raise your hand, text Mike, let us know. So this first case that was included in your materials is kind of towards the back of the materials. It's a newer case, Thomas v. Forsyth Care Center. I put it at the beginning because I knew it was going to take a little bit of time to kind of explain how this case shook out, the history behind it, and there's some lessons here. I don't think that this is something that we're going to see every day, but I thought it was worthwhile to go ahead and go through it a little bit. So this case, the actual case that's described in the materials is an appellate court decision, which was an appeal from the commission. The commission decision that was appealed was an award of commutation of benefits. So there was a motion directly to the commission for commutation of benefits after a final award had been entered previously. So the appellate court in this case actually saw this case, Thomas v. Forsyth Care Center, twice. Once on a PTD, all the way up on appeal, and then again in this commutation issue. So a commutation of benefits, it doesn't happen all the time. More often than not, you have a permanent total award for lifetime benefits, and at some point down the road, both parties agree, let's go ahead and commute this into a lump sum and get the commission to approve it, and then those lifetime benefits that are generally paid out weekly are paid out in a lump sum, and the case goes away. Usually both parties are on board for that, and that's how it gets presented to the commission. This particular commission isn't all that excited about commutation. They've taken a really long, hard look at that particular statute, and it's trickier to get that done these days, but I have in my experience seen that they're still doing it. This case was different because this was a one-party motion for commutation. The employee, the claimant, filed the motion for commutation of lifetime permanent total disability benefits to the commission and asked for a lump sum, which they awarded for $318,000 to this 44-year-old claimant. They appealed it. It was affirmed. I'm like, what is going on here? This case It's not something we see every day, and it came out, and I was like, this doesn't sound right. This doesn't sound normal. The case, the final PTD award was entered in 2013, and here we are, 2016, with an appellate court decision on commutation. That seems really fast. So I dug around a little bit, and the other aspect of this case that was kind of interesting was there was mention of attorney's fees or doubling of the award. I'm like, what did the employer and insurer do in this case? I just don't get it. So I looked back at the original ALJ award and kind of unfolded these facts. This case originally, and it sounds all too familiar, in the very, very beginning, a 41-year-old CNA doing work at a care center, assisting a resident, trips over a mat, tweaks her back. She goes to her own physician, eventually goes to a pain management physician. It doesn't really say whether the employer and insurer authorized that care, but she gets to this pain management physician. Throughout the course, this is how I envision this to have gone. Throughout the course of this case, they dig a little, investigate, find out that this particular claimant at 44 years old has had low back pain associated with a hysterectomy, a motor vehicle accident approximately 6 to 8 months prior involving a low back injury, complete with epidural steroid injections and some ablation procedures. This is all within the last 18 months, bilateral carpal tunnel, lifelong migraines. At some point throughout the pain management physician records, there's mention of the amount of Vicodin and methadone that this person is taking. And so doing the work that I do, I'm like, well, that's why they were so upset. This makes a lot of sense why this particular employer and insurer probably got really irritated by this case very early on. And for whatever reason, I don't really know why, but this is kind of how the facts unfolded in my reading of the case. The pain management physician was asked, that apparently I think the employee chose, asked to address causation by the employer and insurer. There was no IME. The pain management physician essentially tagged the employer and insurer with the treatment. Again, this continued to go on, no IME. It goes to a temporary award in 2007, which without a medical causation opinion to rebut the pain management physician, the award was entered in favor of the employee. Then the employer sort of didn't really comply with the temporary award order and didn't really provide the treatment that they needed to, except for to send them eventually about 6 months later to an IME physician who did an okay job of looking at all of the MRI studies, ordered some additional testing, didn't shut it down. It was not a clear medical causation opinion against causation. So again, they probably should have gone ahead and picked it up. She continues to go on and treat. Eventually, they get a pretty decent IME report in 2011. Like, oh my gosh, this was 2005 injury, and the report really was good, but it didn't come about until 2011. By that time, kind of, I think the wheels had come off. The case goes to trial for permanent total disability. She's awarded permanent total disability. Knowing how the case had been handled, I think the attorney was like, the way that this is going, I'm filing the motion for commutation. She walks away with the lump sum. I think here the commission was really strongly influenced by the history of this particular case. Interestingly, the motion for commutation did not include request to commute any sort of future medical benefits. It wasn't sought, so really the employer, the insurer, is going to direct future medical care because that was part of the award, perm total and the future medical. I think it's possible, after reading this under the right circumstances, if it was bad enough and there was enough evidence there to show how much it was going to cost for future medical, and had they gone through all of the formalities of really building that, I don't know, maybe it could have been awarded, maybe not, I don't know. But it wasn't in this case, and it wasn't asked for in this case. I think there's one more. So the question is, is this going to happen? Is this going to happen all the time? It's scary. I mean, to have to really look and think about the way that this cases are handled and what power the commission has. After looking a little more at the history of this case, it doesn't scare me quite as much that they would do this in all cases. I don't feel like, hello?
Yeah.
I don't think that this is going to happen all the time, but I think it's a cautionary tale of what could potentially happen if a case is not handled appropriately. And I'm reminded, just because you have a history and some maybe bad character choices and maybe somebody out on Facebook doing something, logging, building a fire, that's all really good evidence. If you can get it ready, get it into evidence, it's all admissible, but not to lose sight of the fact that you have a workers' compensation claim for an injury that must be properly defended along the way. All that stuff is really helpful, but it clearly isn't going to be enough. And the ALJ really did away with the prior felony convictions in about 2 sentences. She testified that she's a changed person since then and moved on to the next thing. So, I'm reminded going through that, it's nice to know that stuff, but it's not going to be enough, especially if you're not working the case up appropriately. So there are some questions here. What is it going to look like? I think that this isn't necessarily a trend case as much as it is a cautionary tale, but I think that the commission is clearly willing to entertain it, and under the right circumstances, I don't know where kind of the end is for something like that in the future.
And no, Michelle mentioned it earlier, there was a mention about penalties being applied in this case. In Illinois, this would be a penalties situation. I think you would be looking at the very least, a petition for penalties and attorney's fees, which would likely be awarded by an arbitrator and the commission if this set of facts were to occur in Illinois.
And it's funny to me too, had I lost, I wouldn't be all that excited about going back to the same appellate court within like 3 years. They haven't forgotten what they just saw, and now they're going to be faced with the exact same case again. I don't know that was particularly helpful. And the commission in this, for the commission here was the 2-panel commission. Commissioner Larson hadn't been appointed yet. So that's another piece of the puzzle that we kind of, now that it's a full panel at the commission with Commissioner Larson there, the decision might have read a little bit differently too. How, I'm not exactly sure, but the next case is a right versus second injury fund. This is a second injury fund case, but it had some analysis that I thought was important to everybody in this room. It's an Eastern District Court of Appeals case. The employer wisely settled and got out. So that's why it's just a second injury fund. The claimant sustained an injury to his low back while he was eating lunch, and I'm going to kind of stress the important pieces of the puzzle here. He was eating lunch off the clock, but on the employer's premises, in the employer's lunchroom, on the employer's chair, when the chair collapsed. So I think here kind of the takeaway is the risk assessment for this type of case. The court essentially signified that had the claim been, I got hurt while I was sitting down, the act of sitting down, probably not compensable because you do that outside of work. But he got hurt sitting on the chair in the lunchroom, on the employer's chair in the employer's lunchroom when the chair collapsed, and that chair he wouldn't have encountered in his normal non-employment life. So I think that that's the takeaway there. Permanent total disability benefits, lifetime benefits against the fund in the process. What do we want to ask ourselves, really, whether the risk of injury from that action is equally present outside of work, kind of as I just demonstrated with the sitting versus sitting in a chair, or whether there's some causal connection to the work. Kind of sounds eerily similar to the case that Mike talked about in Illinois. So people that do Illinois and Missouri are going to start to wonder if these cases are sounding similar, and they are kind of sounding a little bit similar. So where there's any way to make a causal connection to the work, I think the commission is probably going to make that connection. If the claimant's attorney is able to articulate it, connecting something to the work, we're in a little bit of trouble. The test really is identify the risk source of the injury and compare that risk to normal non-employment life. We're hired to get creative and to make arguments and describe the risk to make it sound like, you know, in the right situation, that it is something that you would encounter in your non-employment life. But know that, especially with cases like this out there, that we're going to be met with anything and everything they can throw at it to make a causal connection to the work. The next case, Archer versus City of Cameron. This is a working perm total case. In this case, this guy herniated a disc with radicular symptoms in 2008. In 2008, he had permanent restrictions, was brought back to work, worked for 2 years, worked until 2010. In 2010, he has some minor injury at work, files claims for 2008 injury and 2010. So here's how this kind of goes. The cases were tried together. The original award from the ALJ found 35% PPD from the bad 2008 injury and 7.5% from the more minor 2010 injury. Second injury fund was hit with perm total benefits. The second injury fund appealed the 2008 case alleging perm total. The employee appealed the 2010 case to preserve the argument just in case. The employer appealed nothing, so they were content with the way that everything had worked out. So on appeal, they were asked, and the commission said, oh no, you know what, I think you're right. Second injury fund, you're off the hook. This is a perm total from the 2008 case against the employer and the insurer. So despite the fact that this person went back to work and worked for 2 more years, there was a finding of fact by the commission that said there was no credible evidence for a permanent partial disability award from the 2010 case. They had to do that to negate it and to be able to bring it all the way back to the 2008 claim. And now you have an employer-insurer perm total, even though that employer-insurer brought that person back for 2 years.
With restrictions or without restrictions?
He had permanent restrictions. And so he was getting help with heavy lifting. He's getting help from his coworkers. He's taking breaks throughout the day. But he was there. He was doing it. So that's the analysis that sort of the Court of Appeals did. You know, and it said claimants are not prevented from being perm total simply because they hold limited, sporadic, or highly accommodated employment. And it was a question of fact, and they looked back and had to defer to the findings of fact by the commission. And the commission was careful about the findings of fact that they issued to make the award stick. You know, Jerry Richardson, we did a presentation last year. I think he's here today. I think that this kind of tiptoes up really close to some employment law, ADA issues, and how that all gets ferreted out. You know, they brought him back and were accommodating him. Had they not accommodated him, I don't know. Clearly, the commission, if you accommodate too heavily, they may still find perm total disability. Not good. So, next slide. I just got a 2-minute warning. So here, Kohler, this is quick. Kohler is the multiplicity case. That's all fine and well. Defense bar, thank you for your creative arguments that there is no load factor, no multiplicity factor. Too bad, so sad, it totally exists. Case law says so. I appreciate the effort, but multiplicity is totally on the table. All right. And the next case is Greer versus Cisco. This is a TTD after MMI decision. The claimant sustained a crush injury to his foot in 2006. He was treated and released in 2007. He voluntarily resigned his position later that year in November of 2007. After that, he still has plaints, a lot of symptoms. Eventually, he was diagnosed with tarsal tunnel in 2010. The defense expert, I like this, even testified that the surgery that was proposed in 2010 had a predictably poor result. They told this guy it's not going to help. Nobody really thought it was going to help. It didn't help. It made him worse. The result was immaterial. The court even said so. So even if the treatment doesn't help, whether or not, they don't care. It's immaterial. The question was, the award was originally the ALJ, PPD of the left foot, no perm total, and denied benefits after 2007. The commission modified the ALJ award to include the TTD benefits, additional medical expenses after the MMI date in 2007. And the Court of Appeals affirmed. The Supreme Court weighed in. It's a pretty lengthy opinion. They were thorough to say MMI is great. MMI is nowhere in the statute. MMI is in case law. It generally coincides with the point in time where the rehabilitative process concludes. But that's not true in every single case. So our catchphrase from the Greer case is rehabilitative process. So long as someone is in the rehabilitative process, even after MMI, there is now exposure, I think, for TTD. Now, I think that there's arguments, and this is going to kind of create a lot of questions for our experts as far as even after MMI, was that treatment reasonable and necessary from the work injury? Is it causally related to the work injury? What were they doing during the rehabilitative process? Could they have worked during the rehabilitative process? So this is TTD after someone has already determined that that person has reached MMI during some sort of treatment process. The court went on to they discussed, well, the statute allows for 400 weeks of TTD, so clearly the legislature understood that rehabilitation can take a long time. I was like, oh, brother. That's probably, I don't know that that's really what they were thinking when they did it, but 400 weeks is a long time, and the court has opened the door to arguments for rehabilitative process, TTD time off work after a point of MMI. It's frightening. And then the other little twist and downer in that case was originally there was a safety penalty, a 25% reduction in benefits because the employee had violated a safety rule at the employer. He stuck his foot out. I guess there's like traffic basically with forklifts crossing, and you're not supposed to stick your foot out, and he stuck his foot out. And the commission reversed that and removed the 25% credit that the employer was awarded because they said that the employer didn't prove that the claimant had actual knowledge of the safety rule. So not only were there additional benefits, but that 25% credit that would have eased the blow was removed as well. That's why we always like to see those, the handbook safety notes signed off on, initialed, actual knowledge of the safety rule. I don't know exactly what the evidence was, but that was taken off the table also.
I often refer to the case law update presentations as the doom and gloom presentations. So now that we've successfully managed to bum you out this afternoon, are there any questions that we can maybe answer that would help uplift your spirits as we go into the next presentation before Mike comes up here and throws the microphone at me? All right. As we said earlier, Michelle and I will be around the rest of the afternoon. Jenny's sitting over there. I saw Max sitting over there. If you have any questions, please feel free to corner us, and we're more than happy to answer them.
Thank you.
Thank you.